Adam, can you tell me what makes the Legal Ombudsman Service unique and different to the Legal Complaints Service?
Certainly is not unique because I'm setting up an ombudsman scheme, and that ombudsman scheme is based on a model which is used in relation to other professions. It, however, will be different. The powers will be different, but more particularly the approach will be different. The Legal Complaints Service still acts in many ways as a body within the legal profession, so the approach it takes is still very adversarial. It goes to the lawyer for their comments on what the complainant has said, takes that back to the complainant, gets the comments of the complainant, and often you have this rather unhealthy game of ping-pong being played between both sides. We don't take an adversarial approach, we take an inquisitorial approach. We will search out the evidence we need. We're not interested in either party making their case and us then deciding between us. We will investigate all that we need to investigate. We will be much more informal than the Legal Complaints Service. We will be working principally over the phone if we can, certainly using modern technology. We'll also be looking very critically to try and come to an informal resolution. So the people that I'm employing, unlike the Legal Complaints Service, are not necessarily trained lawyers. They're people with keen analytical brains but critically good interpersonal skills, because so much of what's gone on between a lawyer and complainant is a breakdown in the relationship, and what needs to happen is an emotional, the emotional transaction is almost as important as anything else. Finally, in the decisions that we take decisions on a different base from the Legal Complaints Service. We're not interested as to whether the rules are followed. We're interested in whether people got good customer service. It's a very different test. And what we decide is the case if we have to impose a solution, is a solution which is statutory and can be enforced. Unlike the Legal Complaints Service, we have much stronger powers to enforce the decisions we take.
Adam, can you tell me what is going to be the timescale for dealing with a complaint?
Well, we're still working on precisely what the timescales will be. This is an entirely untried system, and frankly, I have no firm idea about how long the complaints are going to take from start to finish. Partly the timescales will be set by how quickly lawyers and indeed complainants get back to us with the information we need. At the moment, the Legal Complaints Service, once it opens a complaint, and that's actually quite a lengthy process in itself, but once it starts investigating, it aims to investigate most cases within 3 months, and certainly we want to match, if not beat that.
Can you tell us what's going to happen to the complaints which are currently being investigated by the Legal Complaints Service after the Ombudsman goes live in October?
The Ombudsman will take over on the 6th of October. Now, all the complaints that have been opened with the Legal Complaints Service before the 6th of October will stay with the Legal Complaints Service to be investigated and completed. And the LCS will stay open until certainly the end of 2010, arguably until March 2011, to work off completely the tail of investigations it's still mounting. Any complaint that's new, any complaints that's not been raised before the 6th of October will come to us, and we'll start work on that.
Okay. And in terms of the investigation itself, how is that going to be conducted? Is it going to be conducted by meetings, over the telephone, electronically? The starting point with the investigation will, as I said, be to ask for the law firm's complaint file, and that should contain the vast majority of the information we need. Thereafter, what we would hope is that most of the work can be done by email and by phone call. We're certainly aiming to use the quickest mechanisms possible, and email and phone call are those mechanisms. I do have a power to have face-to-face meetings and hearings. I'm not intending to use that power very often, but there may be cases where that's the only way forward. Obviously, the Legal Ombudsman's decision will be binding, but is there a right of appeal?
There's no formal right of appeal to the Ombudsman's decision. By the time the Ombudsman takes his decision, there should be no surprise. What will happen is, at the end of the investigation, the investigator will write a recommendation report, and that report will go to both parties, both the complainant and the lawyer, and they will have the opportunity to comment on the recommendation report before that recommendation is made to the Ombudsman. When the Ombudsman receives the recommendation, then the Ombudsman takes a decision whether or not to endorse the recommendation. If the Ombudsman disagrees with the investigator, then there'll be a further opportunity for people to comment on the Ombudsman's decision, provisional decision, before it's finalised. Once it is finalised, though, there is no appeal, although as a public servant I can be judicially reviewed, and to be honest, I fully expect to be judicially reviewed. If we've got it plainly wrong, if my decision is Wednesbury unreasonable, well, it deserves to be overturned.
What are the enforcement options available to the Ombudsman if the lawyer refuses to comply with the Ombudsman's finding?
The Ombudsman does have statutory powers for enforcement, and that enforcement is enforcement of decisions, but also enforcement of corporations. We can compel lawyers to answer questions, we can compel lawyers to disclose documents. The powers that we have are equivalent to those of a contempt of court. I will simply, if necessary, go to a court and get the court to issue a warrant, and that's the way it would work. I can't easily envisage that happening very often. It's certainly not something we're planning to do very often, and in the vast majority of cases I know that lawyers will only be too happy to cooperate with us.
I think it's fair to say, Adam, that many members are concerned about the fee that's going to be applied when the Ombudsman investigates a complaint. Can you tell us a little bit about how this is going to work?
Well, the Act requires me to charge a case fee. The Act says that there are two mechanics which pay for the service that's offered. There is a levy on the profession, which is done through the practising certificate, which is the way that the legal complaint service is paid for at the moment. And the Act says that I must charge a fee for each case that I investigate. Now, I'm not comfortable with that. That has some real difficulties in how that is, you're quite right, in how that's to be enforced. The decision we've taken after consulting the profession extensively is to charge a case fee of £400 whence we accept a complaint for investigation, but only actually charge that case fee where the firm which is the subject of the complaint has had at least 2 previous complaints investigated against them in the previous 12 months. Now, I have a power to waive the case fee, and if it emerges at the end of the investigation that really there was no basis for the complaint at all, and that the actions of the complainant in bringing the complaint were pretty unreasonable, of course I'll waive the case fee.